Right, straight national, as Barbara Armstrong said.
And I'm going to turn the microphone over to the moderator of our first panel, Bob Gordon.
Well, welcome everybody, and this is a great panel here. There are biographies of the panelists in the brochure, so I won't take a long time introducing them. They'll be speaking in the following order. First, Professor Peter Strauss of Columbia, who I think you could call one of the princes of administrative law, one of the very, very few. He's written so much that he himself has probably not read it all. And though I must say I have a personal favorite among his output, and that's his history of the Overton Park case, which is marvelously informative and completely changes your mind, not only about what happened in that case, but about the doctrine itself. He'll be followed. He's going to give a very general overall perspective. He will be followed by Aditya Bamzai, counsel in the U.S. Department of Justice, and who has written an enormously long and erudite history of the administrative law and the Constitution of the United States. Then we switch into the relative present with my colleague Michele Dauber, and here she is, and who has written a prize-winning and quite extraordinarily interesting book on the history of the welfare and emergency relief in the United States. And our the panelist will be Daniel Ernst, who has written one book about the way that the administrative state got received and legitimated in the 20th century, and is now finishing up a book on lawyers in the New Deal, looking at lawyers at various New Deal agencies, and I think it's going to be an eye-opener on that subject. Anyway, welcome to all of the panelists, and let's start with Professor Strauss. I'm going to keep fairly strict time because we have more panelists than usual, but we have to finish at 10:30. Peter.
Thank you. Is the mic working? Yes? Okay, good. 23 decades and 15 minutes, that's a little tight. And I ought to start out in part by thanking Mitch for his introduction yesterday and saying, as will be clear to you, that I'm one of those ameliorists, that we can patch things up, that our job as administrative lawyers today is to make the administrative state as faithful as we possibly can to the Constitution that we have, that was written 23 or so decades ago. I want to start, actually, with here in the home of Microsoft, sort of, with a little demonstration of something Microsoft doesn't show you. So this is slide number 1. Here's where I mean to end up. Come on. Here's where I mean to end up. That's slide number 19. They don't tell you you can do that. You enter the number of your slide, you push return, and you go to that slide. And then you enter, and you're right back at slide number 1. You've learned something, right? You learned nothing else. If you learned nothing else. So a certain view of administrative law was suggested by Gary Lawson in this quotation, and the Constitution by Gary Lawson in this quotation, which you have seen many times, I'm sure. And this thought has been repeated by my colleague Philip Hamburger, and picked up quite recently with a profusion of citations to his administrative law unlawful by Justice Thomas in a couple of concurrences that appeared on the same day, March 9th of this year. I would return to the original understanding of the federal legislative power and require that the federal government create generally applicable rules of private conduct only through the constitutionally prescribed legislative process. And it's my work, I suppose, to persuade you that that shouldn't be done, and effectively really can't be done, And I want to start in this with what seems to me the evident judgment in our Constitution, that it's up to Congress to create the government. The thing that is missing from the Constitution, wholly missing from the Constitution, well, almost wholly, is the government of the United States. What's there is Congress and the President and the Supreme Court. But if you look for the government, you can only find it in these very occasional references to any department or officer thereof. But it doesn't tell you what the departments are or what kind of authority they have. This brings to mind, at least for me, what's a distinct oddity in the necessary and proper clause, which isn't much noticed in the literature. So it says, make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Well, look in the Constitution for any power that is vested in the government as such, or in particular in any department or officer other than the President and the Vice President, and you won't find it. So what is this language doing there? It's probably the residue of an earlier draft, which named specific departments and gave them broadly defined duties, and then said, as the Constitution still does say, that the President can require written opinions respecting the department's head's exercise of these duties. And that draft also said that the President shall in all cases exercise his own judgment and either conform to such opinions or not as he may think proper. So that language had stayed in the Constitution past this draft. The current debates, which we all know about, is whether the President is a strong executive who's capable of taking any decision that may be committed to domestic government, would have been settled by the Constitution's language. But that language didn't stay in the Constitution. It got dropped so that what remains in Article 2 is just that the President may require the opinion in writing of the principal officers of each of the executive departments, there they are again, on any subject relating to the duties of their respective officers. And those of you who know the writing that I've done in the past will be aware that I put a lot of emphasis on this, and also take care that the laws be faithfully executed, as if somebody else was actually going to do it, passive voice, as indicating that in this Constitution, the President's role is to be overseer and not decider. If that prior language had stayed, his role as decider would be pretty clear, but that language got dropped. And it's a kind of conventional interpretive move. When you see language that would have settled an issue being dropped from the draft and not subsequently adopted, to say, well, okay, they decided against that one. But that is perhaps, that's perhaps not necessary. So here we have one thing in our constitutional history, that the one thing that is said, the only thing that is said about the President's relationship to domestic government, other than he gets to appoint the heads of those departments that Congress has the right to create, is that he can ask for their opinions in writing about how they're going to perform their duties. In writing might be significant. That is to say, it's not just a phone call or a private conversation of which there would be no record. It's got to be in writing that you ask for my opinion. And in writing is something that could become public. Might not become public, but it could become public. Indeed, Congress one might even think that Congress could enact a statute if it chose to, requiring that those writings be made public. Hasn't done that. Probably smart for it not to have done that. President Truman once remarked that he depended on his subordinates for advice, but if that advice had to be given in public, he couldn't trust it, and I think that's probably right. Nonetheless, in writing is there. And the other thing that's there is the president shall be commander-in-chief of the military. Commander-in-chief of the military. But just only thing, opinions in writing from those in domestic government who have duties. That's a striking contrast. And for me, it has a considerable significance. There are those who argue that from the start, at the start, we really had a strong executive voice, a president who was clearly in charge. But the work, among others, of Jerry Michele in this wonderful book of his about the lost 100 years of American administrative law ought to have established for all of us, if we hadn't realized it before, that in fact things were much more varied than that. That Congress made a variety of choices about the way in which they were structuring government from the start, differing terms of office for differing officials, and some of them quite independent of the president, the controller of the currency. There's John Locke on rulemaking. I want to say a bit more about him a bit further on. But as against John Locke, the idea which is there from the beginning that regulations are subordinate and they're developed by means other than the exercise of legislative power in the way in which the Constitution says legislative power is to be exercised. And this wonderful early example that Jerry turned up of the Steamboat Commission in the 1840s, which was as independent as any American agency ever has been, and also totally successful, well, not totally, significantly successful in reducing the hazards of exploding boilers in steamboat transportation. So back to John Locke, just as an example of one of those original views that can't be, just can't be affected. Undoubtedly, I mean, this is Locke's view, and undoubtedly Locke's views and Montesquieu's and others were influential at the time of the founding, but it was for a much smaller government than we currently have, and even within that smaller government, the Lockean perspective was quickly dispersed in the decision to authorize the courts to adopt rules of procedure. Now, was that transferring the authority of making laws into other hands, or was it transferring the authority of making regulations subject to the Constitution and subject to such laws as Congress might enact into other hands, which for me is the decisional issue. Moving forward in some sense historically, another thing about differences between perhaps the original view and the current view. This is a favorite passage of mine from Marbury, or passages of mine from Marbury versus Madison, which clearly doesn't apply in the current day. And I want to point out, anticipating perhaps a little bit what Aditya is going to be telling us, that it's not just about mandamus. What Marshall says in Marbury versus Madison is, if the heads of departments possess a legal discretion, nothing can be more perfectly clear than that their acts are only politically examinable. Questions in their nature political, or which are, by the laws submitted to the executive, can never be made in court. That was the view back then by somebody who was present at the drafting. The three lines below it are lines written by Harold Leventhal on the DC Circuit that, for me, state the contemporary truth about and the necessary truth about our understanding of the Constitution in relationship to delegated authority. Congress has been willing to delegate its legislative powers broadly, and courts have upheld such delegation because there is judicial review to assure the legality of the delegations. That review may or may not be sufficiently aggressive. I don't want to get into just how tightly can the delegation doctrine constrain Congress's conferral of authority, but what I do want to do is point out to you the difference between this necessary condition of the creation of authority, because there is judicial review to assure legality, and Marshall. When the executive possesses a legal discretion, nothing can be more perfectly clear than that their acts are only politically examinable. Now, Marshall was talking about the Secretary of State, and there remain a bunch of appointments for and a bunch of actors for which that may be true. I'll get back to that in a couple of moments. But it's not true of the head of the Environmental Protection Agency, or for that matter, the Nuclear Regulatory Commission. They legitimately possess the authority they possess as we currently understand the Constitution, and I would say properly understand the Constitution, because the discretion that they have been given is subject. When I'm teaching administrative law, I have rather a reputation of drawing this distinction by saying, well, so Marshall is writing about discretion. And what we are concerned about in this course is discretion. Discretion is and must be, the exercise of discretion is and must be subject to judicial review. It can exist only because judicial review is available. As the Secretary of Interior learned to his unhappiness in a case involving the gambling laws in South Dakota, where he insisted to the Eighth Circuit that, well, his decision in a certain case was not reviewable because it had been committed to his discretion. Court leaned forward and said, "Are you sure you want to make that argument, counsel?" And the counsel said, "Yes, that's you. Goodbye, court. You've got no business reviewing us." And the court promptly issued an opinion saying here's been an unlawful delegation of legislative authority. Solicitor General persuaded the Secretary of Interior to recant and to discover that there were, in fact, even principles on the basis of which it could be reviewed. I've been given a time warning, which I'll try to respect, but let me show you very quickly no, not that one. Two other things just to suggest the contemporary irrelevance of original understandings. This Freytag versus Commissioner, a case that was repudiated in the PCAOP case, said, on a proper understanding of the original understanding, that the power of heads of departments to make appointments had to be tightly constrained, because this, after all, was a protection against political abuse. So it could only be cabinet officers. And then there was this weird footnote saying, well, we're not deciding about the Federal Trade Commission, the Federal Energy Regulatory Commission, or the Federal Bank of St. Louis. This got overridden in Free Enterprise Institute versus the Public Company Accounting Oversight Board, where the court said, well, no, of course the SEC is a department. And so it properly holds the power of appointment over the members of this board, because they can't do it on a no dismissal except for cause basis. And then another weird footnote. We express no view on whether the commission is thus an executive department under the opinions clause. What? Well, but it's a department, and the only thing that the Constitution says about the president's power, authority over domestic government beyond the Appointments Clause, is that he can require the opinion in writing of the principal officers in each of the executive departments on any subject relating to the duties of their respective offices. If the president wants the opinion from the SEC about some issue, they better give him that opinion, or they will have subjected themselves to dismissal for cause because they have been insubordinate. And if anything has to be cause, it has to be insubordination. Okay, well, there's more that we can get to, maybe your questions and answers. Can we make our written constitution work in the 21st century? Locke is not available, but enforcing the subordinate nature of rules, that is, that they have to be authorized, justified, subjected to judicial check for legality, is not unavailable. And the distinction that Myers repudiates, Myers versus the United States, those are the slides I've skipped, between discretion and discretion has to be observed. Freitag is unworkable, but if the SEC is an element of the executive branch, it has to be subject to presidential oversight, and that means opinions in writing. Thanks.
Thank you.
The slideshow.
Aditya.
Turn this on by hitting the power. Thank you, Bob, Michael, Judd. In light of Bob's introduction and this name card, I should note that I'm not here today in any sort of official capacity, but rather as an enthusiast for obscure jurisprudential developments during the 19th century. Everybody has to have a hobby. With that caveat, I am going to address the doctrinal roots and development of everybody's favorite administrative law doctrine, the doctrine of judicial deference to executive statutory interpretation, now commonly associated with everybody's favorite administrative law case, Chevron. The basic question I'm going to ask is, from where did this doctrine come, intellectually and jurisprudentially? In general, nowadays, there are two distinct theories on offer for the doctrine's roots, and then there's a third theory that was crucial to its development, but is now more or less dropped by the wayside. I will discuss all three. The first theory stems from the Chevron opinion itself. In Chevron, the court claimed the interpretive theory that it was pronouncing had roots stretching back to the 19th century. The oldest case cited by Chevron is the court's 1827 opinion in Edwards-Lessee versus Darby. And here's the relevant language from Edwards-Lessee. Quote, in the construction of a doubtful and ambiguous law, the contemporaneous construction of those who were called upon to act under the law and were appointed to carry its provisions into effect is entitled to very great respect. That sounds an awful lot like the 20th century notion of judicial deference to executive statutory interpretation. And look at the date, 1827, that's Chief Justice Marshall Court territory. And Edwards-Lessee is one among many cases from that time period announcing a similar rule of statutory interpretation. So what are these cases about? Here's my view. The Edwards-Lessee line of cases, they're not about deference to executive interpretation qua executive interpretation. Rather, they are about deference to contemporaneous and customary interpretation that incidentally is executive or that is persuasive because it's executive. Before you object that I've basically, someone agrees. Before you object that I've basically, no sweat, that I've basically said the same thing twice while rearranging the words, let me illustrate the point with an example. In the recent recess appointments case, which I'm basically picking at random, Justice Breyer's opinion cites 3 opinions of the Attorney General of the United States from 1868 in the course of construing the Constitution. Why is that? Isn't it the judicial function to interpret law rather than the executive function? Well, the obvious answer is that the court respects or defers to certain persuasive sources that are either roughly contemporaneous with the enactment of a constitutional provision or provide evidence of a customary practice under that provision. The Edwards-Lessee line of precedents, and there are a lot of them from the 19th century, they applied the exact same interpretive approach in the context of statutes. And how do we know that? Several points. The cases invoke legal treatises articulating 2 Latin canons of construction. I won't mangle the pronunciation of the Latin formulations, but the English translations are 1, a contemporaneous exposition is the best and most powerful in law, and 2, usage is the best interpreter of laws. Some cases even invoke the maxims in their Latin form. The cases intermingle precedents about constitutional, statutory, and even contract interpretation, indicating that the courts were using a generalized theory of interpretation rather than a specialized theory about statutes. The cases reject changed executive interpretations in favor of contemporaneous or customary practices, and treatises from the early 19th century to the turn of the 20th century that discuss the cases collect them under the heading of usage or practice or contemporaneous understanding. The bottom line is that on the plane of statutory interpretation theory, there was a rule of deference, but it was a rule of deference to customary practice and contemporaneous evidence, rather than the rule of deference that we're more familiar with today. The Edwards-Lessee line of cases cited in Chevron, they're merely an application of this generalized approach to interpretation, which was used in constitutional and statutory cases alike. And I'll just note parenthetically, one of the reasons why I started down this project is I thought to myself, why would statutory interpretation be conducted differently in 1828 from constitutional interpretation? Why would there be a general interpretive framework that was different for one than from the other? So let's move on to the second theory that's on offer for the doctrinal basis for Chevron, what we can call the mandamus theory, which was floated by Justice Scalia in his dissent in United States versus Meade Corporation and repeated by him just a few weeks ago in his concurrence in Perez versus Mortgage Bankers. Let me also just note parenthetically that we should discuss the Marbury quote that Peter mentions in his own discussion. I agree with him on his interpretation of that quote. It's very interesting how all these things play into one another. But I'll do that maybe in our discussion after the talks. Both of Justice Scalia's opinions suggest that deference can be understood as consistent with the origins of judicial review, which was principally exercised through the writ of mandamus in the early republic. And the writ of mandamus wouldn't issue unless the executive officer was acting plainly outside the scope of his authority and had violated the language is ministerial duty. So what's this about? Why in the early American Republic did it take a writ of mandamus to obtain judicial review of many statutory questions? The basic answer, I believe, is that during much of the 19th century, there was no general federal question equity jurisdiction. The Federalist Congress had briefly created it before President Jefferson took office. The newly enacted Democratic Republicans repealed it almost immediately. And as a result, to get review of violations of statutory rights, you had to pursue one of two options. First option, one way you could get review was by trying to pigeonhole your claim into a common law cause of action. So to illustrate, if the Federal Land Department issued a grant to claimant A under certain statutory authority and claimant B disputed that grant, the legal question of the department's statutory authority could and often was litigated in a trespass action between the two claimants. But many statutory violations don't fit neatly into a common law cause of action. So let's say that an executive branch official misinterpreted the law in distributing pension benefits. The person seeking the benefits would not have a readily available common law right to vindicate a claim. The second avenue was as follows. Through a complicated series of opinions, the Marshall Court held that although the Supreme Court lacked authority to issue mandamus directly to executive officers, that's Marbury versus Madison, the Circuit Court for the District of Columbia did have such authority, but a plaintiff seeking the writ of mandamus had to show that the executive officer had violated a ministerial duty. In an 1840 case, Decatur versus Paulding, Chief Justice Taney held that this standard conferred interpretive discretion on executive officers so that the act of interpreting a statute was non-ministerial and hence not reviewable by mandamus. At the same time, however, Decatur drew a distinction between direct challenges to executive action using a writ and cases in which the federal courts had other forms of jurisdiction, So here's Chief Justice Taney's language. He says, if a suit should come before this court which involved the construction of any of these laws, the court certainly would not be bound to adopt the construction given by the head of a department. And I think what he's talking about is my hypothetical with the claimant A, claimant B land department cases. So the interpretive deference that Taney is articulating in Decatur appears to be about a type of challenge, the type of challenge involved in the case, rather than a theory of statutory interpretation generally. Here's the critical point. Between 1840, when Decatur is decided, and the early 20th century, the mandamus standard loses its salience in judicial review of executive action. It's basically forgotten. Here are two theories for why that might have occurred. First, Congress reintroduces general federal question equity jurisdiction in 1875, along with various other bases of jurisdiction for suit against the government. And the existence of these statutes has the effect of mooting out the need to use a writ of mandamus to obtain judicial review of executive action. Second, I suppose one could connect this jurisprudential development to other jurisprudential developments on the court in around the same time period. So this is the era of ex parte Young, for example. I think the court is more comfortable issuing injunctions to executive officials than perhaps it had been earlier. The bottom line is that by the time we hit the progressive thinkers and the New Dealers of the 1920s and 1930s, people who were very interested in expanding the scope of executive interpretive authority, they don't invoke the mandamus line of cases as precedent. That's not the theory. That's not the lens through which they are using, that they're trying to advocate an expansion of judicial deference, which is interesting because they could have said in 1920 or 30, let's revert to the status quo ante, what was going on about 50 odd years ago, but that's not their theory. So the third theory is their theory. This is the one that many advocates for enhanced deference in the 1930s embraced. By the 1930s, there was a fairly clear distinction drawn between questions of fact, which were reviewed under a deferential standard, and questions of law, which were not. That raised the following question. What's the difference between law and fact in this context? In an influential 1898 treatise addressing the law of evidence, not administrative law, James Bradley Thayer had argued that law and fact, what went to a jury and what went to a judge, were not these a priori or Platonic categories, but rather classification in one category or the other was basically a policy decision. Who was the best decision maker on a particular question? 3 decades later, a young professor named John Dickinson wrote a treatise that picks up on Thayer's point, citing Thayer expressly, from evidence law and applies it to judicial review of administrative action. So like Thayer, his argument is that it's impossible to establish a clear line between questions of law and fact. And he has a somewhat poetic way of putting it, so I'll quote that. He says, matters of law grow downward into roots of fact, and matters of fact reach upward without a break into matters of law. The knife of policy alone affects an artificial cleavage at the point where the court chooses to draw the line between public interest and private right. This was a highly influential argument for enhanced judicial deference to executive statutory interpretation in the mid-20th century. For example, the report of the Attorney General's Committee on Administrative Procedure, issued in 1941, observes that a court addressing a legal question, quote, might approach it somewhat as a question of fact to ascertain not the right interpretation, but only whether the administrative interpretation has substantial support, citing Dickinson. So you can see a line between Thayer, Dickinson, Attorney General's report. So those are the 3 general theories for the origins of judicial deference to executive statutory interpretation, as well as my critique, some explicit, some implicit of each of them. Let me close by offering 2 takeaways from the historical discussion. First, I think the conventional wisdom has tended to be that prior to Chevron, courts pursued a multi-factor, ad hoc, untheorized, and unexplained approach to the question of when to give deference to executive statutory interpretation. I don't believe that conventional wisdom is correct. There was a lot more coherence to the law of the 19th century than we have given it credit thus far, and there was a lot more intellectual energy expended on deciding or trying to describe the proper metes and bounds of these types of doctrines. Studying the law rather than dismissing it as part of some sort of primordial stew might give us insight into how best to create our own institutions. But second, one important aspect of the history is that the framework I've outlined, with the canons of construction style approach and the mandamus standard being mooted out, that was the legal framework that the lawyers of the early 20th century inherited. And more importantly, that was the framework against which the debates that led up to the enactment of the Administrative Procedure Act in 1946 occurred. The APA, of course, has a standard of review provision, which requires reviewing courts to decide all relevant questions of law and to interpret constitutional and statutory provisions. Interpreting those terms in the APA poses all the normal thorny issues of trying to divine congressional meaning. The key point I want to leave you with is that engaging in that kind of interpretive task is only possible if we try to understand the pre-existing legal framework that Congress was legislating against, the backdrop against which it was legislating, and try to understand the doctrines it was seeking to incorporate or perhaps repudiate. And that's one example of why understanding constitutional history is important to the task of understanding administrative law. Thank you, Bob.
Good morning. I want to thank you all for inviting me to talk to you today about this topic. I'm going to pick up chronologically where you left off and talk about the New Deal and some of the time immediately prior to it. So in November 1935, Harvard law professor Felix Frankfurter wrote to his longtime friend Jerome Frank, who was then the special counsel to the Public Works Administration. And Frank was directing the defense of a federal program that built municipal power plants that would compete with private utilities. Southern power companies like the South Carolina giant Duke Power sued the government to stop the program, arguing that the federal government lacked the authority to operate that kind of a program. And Frankfurter, who had recommended Frank for his first government job back in 1933, warned Frank against portraying the agency as a radical innovation. Instead, Frankfurter advised Frank to seek precedents that would establish the PWA's public works programs as firmly in line with traditional concepts of federal authority. Frankfurter was especially worried that his friend's well-known commitment to legal realism would lead him astray. He thought that Frank might decide to disregard precedent in favor of an appeal to necessity. Quote, "Nothing," Frankfurter urged, "seems more important than to avoid arguments of novelty and of potentially far-reaching implications," unquote. And on the contrary, Frank should try to, quote, "employ familiar concepts expressed in very familiar, simple, unarousing language, and abandon any effort to vindicate any realist philosophy or, quote, expose the bunk of old arguments," quote. Now, Frank was irritated at his friend's insistence that he abandon legal realism in order to win his case, but not because he disagreed with the tactical advice. Frank thought Frankfurter's point was so obvious that it was insulting to him to even make it. And clearly wounded, Frank snapped that, quote, "My strategy has been exactly that which is suggested by you, namely to assert on behalf of the government no more power than necessary to justify the precise action heretofore taken by it. You ought to know that I do not believe in trying to vindicate abstract principles, and that to me the important thing is to win particular underlined cases," quote. Furthermore, Frank tartly noted that he, unlike his friend, the law professor, had been practicing law for 21 years, and that his strategy was always to, quote, "take the homeliest illustrations in the simplest possible English, and to bring the facts of the case within the sanction of the least controverted precedents," quote. So to Frank, this was exactly what legal realism would suggest. Because judges prefer to portray their decisions as flowing from precedent, quote, "it is essential to use the particular kind of jargon and articulate one's ideas in terms of the particular kind of precedential language that, so far as one can conjecture, will be the most pleasing to the particular tribunal to which the argument is addressed," quote. Obviously writing in the age before Twitter. Frank knew enough not to argue in court that law was all bunk, and he resented very deeply the suggestion that he would be so naive. And back and forth they went in over half a dozen letters that winter. So beyond eavesdropping their spat, what is the significance of these two friends violently agreeing that the New Deal should be defended as continuous with past practice? And what strikes me is the complete absence of our current understanding of the New Deal as having been a sharp break with past practice and constitutional interpretation, a break that left us with a vastly expanded government and the modern administrative state. From our modern perspective, it's no accident that a cadre of legal realists staffed government legal offices during the New Deal. We think, well, they were the people who wrenched the law in a new direction, these New Dealers, these legal realists. But even dedicated realists like Frank took as an absolute imperative that they had to portray these New Deal programs as entirely continuous with the past. In the case of public power, Social Security, and the other spending clause programs, this was not going to be hard. As realist Thurman Arnold advised then Assistant Attorney General Robert Jackson in September 1936 regarding the government brief in the Social Security cases, the administration should avoid the suggestion that the Social Security Act was in any way going to extend the power of the federal government and instead should emphasize its conformity with the past. In Arnold's view, the case for the constitutionality of the program was conclusive based on legal precedent. Quote, "There are no cases which have to be overruled to sustain the constitutionality of the act." Frank and Frankfurter, Arnold and Jackson were prominent members of a dense network of New Deal lawyers who created and then defended the welfare state programs of the 1930s, including unemployment insurance, old age benefits, mortgage assistance, farm subsidies, slum clearance, public works programs, and others. It's folklore that a great many of these lawyers matriculated at Harvard. This has been routinely attributed to Frankfurter's skilled use of connections on behalf of his students. Less well known, but ultimately more important, I think, to the story of the legal work of the administrative state during the New Deal was the lawyer's connection to Thomas Reed Powell, who taught nearly all of them constitutional law. Powell, in turn, had very strong ties to the political science faculty at Columbia University, where he earned his PhD and taught for many years before returning to Harvard. And it was at Columbia that Powell absorbed the then conventional wisdom that Congress had essentially unlimited power, unreviewable by any court, to spend as it pleased in the general welfare. When Powell returned to Harvard in 1926 as the sole teacher of constitutional law, he brought this idea and the precedents supporting it back with him. So students in his classes, which included some of the most famous New Dealers, including Alger Hiss, who wrote the government's brief in defense of the Agricultural Adjustment Act, and Tom Elliott, who defended the Social Security Act, learned that it was settled law that Congress could appropriate funds regardless of any enumerated power. And the basis for this conviction was an 1896 decision that then was a routine part of the constitutional law curriculum entitled United States versus Realty Company. Does anybody know what United States versus Realty Company was even about, other than you who read the book? Anybody else? Okay. So it's about the sugar bounty, so file that away. Students in Powell's classes studied the extensive history of legislative precedents that supported government spending, specifically for the relief of catastrophes and disasters, and the way that the court had deferred to that history or that practice in Realty Company. So while their law school educations had, of course, emphasized the far more contentious areas of commerce, public utilities, and taxation, it was taken for granted in Thomas Reed Powell's class that federal spending, as opposed to regulation, was basically beyond challenge. And Powell wasn't by himself in this view. This wasn't idiosyncratic. Princeton's Edward Corwin, who was a towering giant in the field of constitutional law, famously predicted that the spending power would lead to what he called, quote, the twilight of the Supreme Court in the Storrs Lecture at Yale, which later became a best-selling book that went through 4 printings right around the time of the Social Security litigation. In fact, all of the major treatises and case books on constitutional law that were in use at Harvard, Columbia, and pretty much every American law school during the time that the New Deal lawyers were educated took this exact same position. So it wasn't controversial, it was mainstream. So faced with the practical task of defending programs like public power, Social Security, slum clearance, and these various things, lawyers for the government drew on the doctrines with which they were most familiar, what they had learned at law school. And remember that for many of these lawyers, this work was their first job. It was their first professional work outside of clerking of any significance. So they sort of clung more rather than less tightly to the things that they learned in law school, and they reached out to each other and to former colleagues and professors to formulate their arguments and their tactics. So even before the Supreme Court decision in Schechter Poultry came down, these lawyers had already started to turn away from the very contested terrain of the commerce power and toward the extremely secure footing of the General Welfare Clause and the Realty Company precedent. Subsequent Supreme Court decisions, for example, United States versus Butler, which was the Agricultural Adjustment Administration case, underlined the importance of giving regulation a very wide berth and made the spending power seem like a safe harbor. So the question was how to most convincingly bring the administrative apparatus of the New Deal state within the ambit of the previous exercises of the General Welfare Clause. The spending power cases themselves provided very clear guidance about how to do this. The briefs and opinions almost always referenced a list of federal disaster relief measures as evidence that the ability of the federal government to spend in the general welfare had long been settled. So New Deal lawyers seized upon both the general principle of unfettered government spending and more specifically the right of the federal government to relieve calamities, catastrophes, and disasters, to argue that the government's relief of the disaster of the Depression was fully consistent with past practices. And nowhere was this clearer than in the case of Social Security. So in the fall of 1934, President Roosevelt appointed the cabinet-level committee, the Committee on Economic Security, to come up with a social insurance bill. And this committee was staffed by, in turn, a group of committees and technical advisors that included policy experts, actuaries, lawyers, law professors. And it's very well known for students of this, people who study this period, that the structure of unemployment and old age insurance was really controversial. Roosevelt himself and members of his inner circle favoring state-level benefits and a federal-state cooperative program rather than what was called a straight national system. The standard account of this resolution, of this fight, by both participants and scholars, is that the constitutional concerns, that is fear of the court, rendered a national plan for unemployment impossible. Most historical accounts cite the Constitution and the old court, the Four Horsemen, as having, basically barred the door to federal level unemployment insurance and having posed a serious threat, in fact, to old age insurance. And in this telling, the reason our present unemployment insurance system is so inadequate is that the Constitution and the court prevented the implementation of any real standards and allowed the South to set essentially its own benefit levels at an outrageously low level with no federal oversight. But on inspection, it turns out that this story is almost entirely false. In fact, the real story of the rejection of national standards in favor of complete state-level freedom is basically the opposite. Lawyers, law professors, and outside legal and constitutional experts who were consulted by the committee agreed in 1934 and 1935 that the straight national plan for unemployment insurance, justified under the broad general welfare clause, would be much, much more likely to be approved by the court than the federal state plan that was eventually adopted. And this is going to sound very familiar to readers of the Medicaid expansion, multiple Medicaid expansion decisions. Indeed, the ability of Congress to tax and spend directly for the relief of the unemployed was considered, and this is a quote, constitutionally bomb-proof. At the time, it was quite clearly political rather than legal or constitutional concerns, and specifically the concern of Southerners to prevent federal interference in their racialized agricultural labor system that caused the administration to abandon all of its efforts at federal standards over unemployment. Had it not been for the determined intervention of one of the lawyers on the committee, who is, in my mind, is sort of the unsung hero of Social Security, or I suppose, devil of Social Security, depending on your politics, Barbara Nachtrieb Armstrong, who was a professor at the University of California Law School. It wasn't for her, I think old age insurance clearly would have also ended up as a federal state program. Social Security is the starkest counterexample to the notion that the New Deal state, the administrative state, required a large-scale constitutional shift or change in order to be upheld. Every lawyer involved in the Committee on Economic Security and in Congress thought not only that the power to tax and appropriate was not only broad enough to encompass the Social Security Act, they thought it justified a lot more than the Social Security Act and a lot more easily. And to put this in modern terms, it would justify single payer much more easily than it would justify the Medicaid expansion. So the reason we don't have single payer isn't a legal reason, it's a political reason. And I think that's obvious to all of us now, just as obvious as it was to all of them then, what they were dealing with. So why then is there such a disjuncture between our kind of retrospective account of the New Deal administrative state as having been this radical break and the contemporary insistence that it was no break at all? Now it might be tempting to chalk this up to historical distance. That is, we can now see how the New Deal brought forth this cascade of changes that have reshaped the American state. But the New Deal lawyers were surely aware of the scope of the changes that they were defending. These were, after all, the first national unemployment and old age pension programs, the first federal slum clearance programs, the first national public housing programs, and so forth. The problem that these lawyers faced was how to transform the uncertainty about the fate of New Deal programs into legal victories. And solving that problem required treating the New Deal as if it were completely unexceptionable in legal terms. Only later, after the court had blessed the programs, was it possible to represent the New Deal as legally innovative without threatening its existence. And in fact, it made them look more heroic to recast it in those terms. We now regard the New Deal lawyers in terms that Robert Jackson and Stanley Reed, who was the Solicitor General at the time, for example, strenuously rejected well beyond the New Deal, which is that it reworked the Constitution in the course of fundamentally remaking the American state.
I want to thank our hosts and apologize to all of you for going a little bit fast. My contribution to this panel are some thoughts about the Constitution, not in the books, but in action, where the action takes place not in civil society, but in the state. For some time now, I've been studying the lawyers of the New Deal and how they've acquired and asserted institutionalized professional authority within their agencies, and in the process help keep the United States a liberal democracy. Lately, my focus has been on two agencies created in the 100 days, the Agricultural Adjustment Administration, or AAA, and the National Recovery Administration, or NRA, through which the Secretary of Agriculture and the President exercised vast discretion over American agriculture and industry. Ira Katznelson has called the 100 Days the most radical economic policy moment in American history. On the whole, New Deal lawyers kept the potential for radical change to the right or to the left from being realized. During the first 2 years of the New Deal, lawyers at AAA and NRA made the most of what the sociologist Terence Halliday has called the unusual opportunity law presents to exercise moral authority in the name of technical advice. Congress had hurriedly created these agencies with broad delegations and little guidance as to how to resolve the innumerable conflicts the lawyers would inevitably confront. As far as the text of the National Industrial Recovery Act went, for example, the philosopher Horace M. Collin observed, the statute may lead us toward democracy in industry. It may lead us toward fascism. Whoever implemented the act would make it an instrument toward one end or the other. At both agencies, administrators came overwhelmingly from industry and sought to escape an antitrust regime that mandated what they considered to be outdated and destructive price competition. The agency's lawyers feared that the cartelization of the economy would hurt consumers, small producers, and labor, and clashed with their ostensible clients, the administrators. Thus, Louis Jaffe characterized his time at AAA as a fight of fringe New Dealers against what actually could be pretty much seen as a scheme for propping up lots of big farmers and increasing the price of wheat. Jaffe accepted without question that the legal division was out to gain certain social objectives and to ensure that big farmers didn't get too much. The lawyers projected their preferred policies onto their organic acts and then insisted that administrators follow them in an assertion of their technical authority. Whether they or the administrators prevailed depended on the preferences and resolve of the agency head. When the NRA's lawyers objected that the proposed lumber code would violate the policies of the Recovery Act. The relevant administrator claimed not to see how the lawyers had raised a legal objection. Over at AAA, the too aptly named Jerome Frank could not keep himself from asserting, in an address reprinted in the congressional record, that lawyers could always find a way to interpret ambiguous statutes so as to arrive at the result they believed desirable. As long as he had the backing of Agricultural Secretary Henry Wallace, Frank prevailed. But when he took sharecroppers' side in a contractual dispute with powerful cotton planters, Wallace declared that Frank had nothing to stand on from a legal point of view and was merely asserting his own social preconceptions. This conference prompts me to consider how the bureaucratic politics of professional authority changed when the law in question was constitutional. The question is worth asking for relationships between agency lawyers and three different groups. They're administrators, Department of Justice lawyers, and Supreme Court justices. The historian Daniel Rogers has written that after the Civil War, lawyers used judicial review to seize a vital chunk of power from legislatures and spiral it upwards into the hands of higher state arbiters. In clashes with their own administrators, AAA and NRA lawyers attempted a similar game of keep away. At NRA, the lumber code was particularly contentious because of its unusually broad delegation of power to a business-dominated code authority. When you tried to do something, a lumberman on the authority recalled, you ran against this government wall. One incident that stayed with him involved the very able and knowledgeable lawyer Bernice Lotwin, whom he could later remember only as, and I quote, some Jew lawyer they had there. She said that we couldn't do something because it was unconstitutional. I said, well, of course that may be true, but so is your NRA unconstitutional. At AAA, Lee Pressman led the charge in the battle over marketing agreements. In December 1933, he sought advice from his former constitutional law professor, Thomas Reed Powell, on which cases arising in the milk industry were most likely to survive a constitutional challenge. As Powell reported to Felix Frankfurter, Pressman hoped that Powell's constitutional prognostications might serve as a lever to influence the policy of the Agricultural Administration, whose chief was altogether too favorably inclined to the big people. Well, as you've just heard, it's not surprising that Pressman turned to Powell. Although no single scholar brought legal realism to constitutional law, none who did was more influential than Powell. The general tradition in the law school, recall Charles E. Wazansky Jr., the Harvard Law School, was to teach law as a kind of disembodied set of principles, which you could understand without being concerned with who it was who announced them. Powell made Wazansky see the development of a single court and how particular individuals develop doctrine. Pressman, in his oral histories, also acknowledged Powell's influence, said that Powell taught that you need to think about how 9 or rather 5 age-worn guys would react to a case. Whether constitutional law was the result of a priori reasoning from text, principles, and precedents, or something more personal to particular justices, had implications for the politics of professional authority. The realist approach altered the ante required to get into the game of constitutional interpretation to a particularized knowledge of particular justices that few could acquire. A full-time court watcher on a law faculty might acquire it, especially if he enjoyed personal access to the thinking of the justices. Frankfurter's close relationship with Louis Brandeis and his skillful cultivation of Harlan Fistone made him a unique case. But legal secretaries might acquire a particularized knowledge of the justices too. Although Frankfurter deprecated secretaries who tittle-tattle too much on what comes to them in their confidential relations, particularly when their advice ran counter to Frankfurter's own, no one did more to funnel them from the court to the Solicitor General's office. Other constitutional realists also valued what they gleaned from the clerks. For example, When Wyszynski attributed his successful arguments in the 1936 term to the methods of Reed Powell, he neglected to mention that his preparations also included conversations with Stone's clerk in the 1935 term. Until early 1935, realist constitutional law held greater sway in the New Deal agencies than in the Department of Justice. The Solicitor General was J. Crawford Biggs, a hapless country lawyer from North Carolina. Harold Stevens, the Assistant Attorney General for the Antitrust Revision, regarded the constitutional realism of the agency lawyers as sophistical and opportunistic. His clash with the agencies culminated in the 1934 term during challenges to the National Industrial Recovery Act. Stevens's argument in Panama refining was a widely noted debacle, and a sharp contrast to Stanley Reed's success in the Gold Clause cases on a brief by Paul Freund. Frankfurter persuaded Roosevelt to make Reed, the General Counsel of the Reconstruction Finance Corporation, Solicitor General. Reed staffed his office with young constitutional realists, including Freund and no fewer than 4 other Supreme Court justices. Wyszynski, who had clerked for the Hands, took a 25% salary cut to join the office. Billed as knowing how to avoid all the social prejudices of socially biased judges in presenting the strictly legal phases of contentious issues, Wyszynski lived up to expectations. His celebrated defense of labor and Social Security statutes legitimated a realist style of constitutional argument and elite cadre of constitutional interpreters situated within the Department of Justice. Well, what about the agency lawyers and the Supreme Court justices? Although conflict predominates in the histories of the Supreme Court and the New Deal, the titles and the subtitles are, The Duel, an epic battle, a constitutional war in which protagonists strive for supreme power. Sort of like Professor Dauber, I think that if you take a long view, what Professor Barry Cushman has called the consultative relationship between the Hughes Court and the Roosevelt administration looms larger, the conflict. Before the New Deal, it's actually the day before Letus Kroll files his certiorari petition in Kroll versus Benson. Chief Justice Charles Evans Hughes declared that the withdrawal from the courts of a host of controversies as to private rights was the distinctive development of our era. Although some justices resisted this development, Hughes did not. He believed that his predecessor, Robert Brooks Taney, had fundamentally erred in supposing that the imperious question of slavery could be put at rest by a judicial pronouncement. To Hughes, the social forces requiring legislative delegations to administrative agencies were scarcely less imperious. Of course, Hughes recognized that legislatures entrusting of the business of regulation to administrative agencies had its own perils. He retained weight of the evidence review of agency fact-finding, but only for the small and, as Mark Tushnet has argued, rapidly shrinking category of jurisdictional and constitutional facts. Further, Hughes insisted that agencies more closely follow the ordinary legal manner of the ordinary courts of the land in their formal adjudications, a move that empowered lawyers outside of the government. But he also looked to the agency lawyers themselves to, quote, protect society from bureaucratic excesses. To empower him, his court held in Panama refining that the Due Process Clause imposed on the federal executive an obligation to support its exercises of a legislative power, such as the codes, with judicially reviewable findings of fact. NRA lawyers realized that the courts had thrown them a lifeline. The requirement of findings, if complied with, goes a long way toward justifying delegation. Milton Katz told the NRA's general counsel, findings must be real findings. Another NRA lawyer hoped that administrators who had previously deprecated the need to support codes with facts would derive a good lesson from Panama refining. For the remainder of their agency's life, NRA lawyers made the most of this judicial endorsement of their technical authority. So did later agency lawyers of varying political persuasions, including Abe Fortas and Harold Leventhal at the Bituminous Coal Division, and John Lord O'Brien at the War Production Board. To conclude, the history of the Constitution and administrative state surely includes sharp clashes and bitter conflict. But that history also includes incremental and carefully considered accommodations aimed at making courts and agencies collaborative instrumentalities of justice. Pace Frankfurter, these accommodations were not a phase of some inevitable adjustment of law to modernizing society, but a political process in which rivals jockeyed for advantage. Sometimes the rivals were lawyers, but the lawyers' rivalry had its limits. When confronted with a thoroughgoing challenge to the authority of the legal profession, they closed ranks and used the Constitution to preserve a decisive role for themselves in the federal administrative state.
Thank you. Let me first ask members of the panel if any of them has a reaction to anything any of the others has said. Peter.
Well, I'm just delighted by the last passages in your presentation, Dan. It teaches me where Harold Leventhal's thought comes from, and I'm going to use that. That's highly persuasive. Aditya and I have had a number of private conversations about his paper, which is just extraordinarily well researched. When you get a chance to read the whole of it, I hope you will. But I want to say just a word about the fact-law distinction that will probably place me in the Dickinson camp. It's an unworkable distinction, as we all know. There's this issue of mixed questions of fact and law, and it seems to me that one way of understanding Chevron, and for that matter, the more recent decision of the Supreme Court in Arlington, City of Arlington versus FCC, is that it reserves the middle ground, which will be defined by courts, the extent of which will be defined by courts, for agencies. That is, step one of Chevron is, what's the agency's authority? Where's the end of the, this is just a question of law question? And the rest of it falls within the Chevron notion. Now, agency, have you acted in a reasonable way? If you read City of Arlington carefully, you will find that it is 9-0 Seems to be a tightly divided opinion, but it is 9-0 on the proposition that it is for the courts ultimately to say what the range of agency authority is. There's a certain disagreement about, okay, how are courts to go about that? Scalia says nothing on the subject. Chief Justice Roberts, in his dissent, says, well, without any deference at all to the agencies. Chief Justice Roberts, in saying that, is giving up on the roughly 200 years of precedent that begins with the Edwards case, where Aditya started. There is a solid 200 years of precedent saying that when courts decide for themselves what the law is, which is ultimately their job, Marbury versus Madison again, they need to give appropriate weight to what agency views are. Not just because agencies have views, but because they're a part of the government that we share, which is, to me, a very strong motivating feature of the Edwards decision. And that's, you may recognize, Skidmore. You look in City versus Arlington, in City of Arlington for Skidmore, you won't find it, except for one mention in Chief Justice Breyer's sole concurrence. It's utterly hidden, utterly unmentioned. From my perspective, it has to have survived.
Sure, if I may. So just a couple of quick thoughts on that. The Loft Act issue is very interesting both as a matter of intellectual history, because parenthetically, John Dickinson, writing in 1927, expounds this theory. Writing in 1947 in the wake of the APA's passage, he has an American Bar Association journal article where he essentially repudiates the theory. So I don't know if he had changed his mind within the intervening 2 decades, or if when he put forward the theory in 1927, he did it in a tentative sort of fashion, and it got picked up by other people who used it more aggressively. That's just an interesting color point. Of course, John Dickinson's own personal progression is not controlling law within the United States. What is, it seems to me, is the text of the APA, which distinguishes between law and fact. And so whatever we may say, or whatever questions we may have about the appropriateness of such a distinction, it is enshrined in the statute. And so it seems to me that the proper way to approach the statute is to try and get at what Congress, when it used those terms, try and get at what they intended in distinguishing between law and fact. So moving on to a second point, and that is the quote that Peter had put up from Marbury about delegations of discretion to executive officers. It's very interesting, and I think that I'm in entire agreement with Peter about the import of that quotation, but it plays out in a couple of different ways, and let me see if I can illustrate with a couple of hypotheticals. So the quote, just to remind you, is, and I'm paraphrasing and taking small snippets because I don't have the entire quote in front of me, but mere political acts belonging to the executive department alone, for the performance of which entire confidence is placed by our Constitution in the supreme executive, for any misconduct respecting which the injured individual has no remedy, there may be such a category of cases, and in those cases the president would be accountable in his own discretion to the country and to his own conscience. So what is Chief Justice Marshall trying to say in that passage? I think what he's trying to say is something like the following. I'm going to use a fanciful example that really is not very realistic, but hopefully illustrates the point. Let's say under the treaty power, the president decides not to negotiate a treaty with a particular country. We have a new administration, and the new administration decides to enter into the precise same treaty with the precise same country. No one would ever think that the previous decision by the earlier president was somehow liquidated the meaning of the treaty power, or was an interpretive gloss on the types of treaties that could be entered into. Rather, the way to look at the way the treaty power is written is that it confers discretion and authority on the executive branch, and they get to choose when and whether to make such decisions. So that, I think, is what Chief Justice Marshall is getting at in these passages. Now, there's a separate class of provisions in the Constitution that are ambiguous, but nevertheless get filled out through historical practice. So there's the Recess Appointments Clause case recently, which I cited, and innumerable number of other cases. The point I think that Marshall is trying to make is that there are two categories of ambiguity. There's one category in which there has been a delegation of authority. There's another category of ambiguity where customary practice will resolve the ambiguity over time. And I think the same basic interpretive framework then translates into the statutory context.
Other comments on the, let's engage the floor if the floor wishes to be engaged. Well, I have a question for our two new dealers. And that is, what are we witnessing here? Are we witnessing, in fact, a revolution in government, under a pretext of constitutional continuity, or are we realizing a revolution in government, which is brought about by the Marshallian process, of executive decision making, which is political, unreviewable, and doesn't present any controversial legal problems?
I think it depends. I think in the case of the general welfare power, it's probably closer to the latter. But, you know, these are all questions of argument. You know, there's no sort of these are legal arguments, right? So what you're asking is, you know, who has the better argument, and that, you know, who knows, right? I mean, in the case of the general welfare clause, the fact is there was no instance of the Supreme Court ever, and still hasn't been a case of, to today, of the Supreme Court ever interrogating whether Congress got the question right or wrong of whether something was in the general welfare and then disagreeing to that. In fact, you know, up to the point of the New Deal and still today, what they've said is, you know, this is basically not justiciable. This is basically a political question. We're not going to get engaged with it. We're not going to interrogate the power of the purse. You know, they've dropped some sort of breadcrumbs and hints and, you know, tiny little ideas that maybe we could, in theory, if something was like super arbitrary, you know, in some, you know, alternate universe that has never happened. So I suppose if you were looking for kind of what's the existential reality, in the case of the general welfare power, it's likely that it's not any kind of revolutionary break with the past. But again, it's all a question of argument, you know.
Sure.
And so, you know, so the smartest people in the country at the time took a look at it and said that was the best and most likeliest way to win. That had implications for what they did, right? I mean, it's not just a question of like the New Deal, the administration did what it wanted to do and then it handed it off to the lawyers to present it in the homeliest possible terms, in the, you know, sort of plainest possible English, and to come up with some sophistry for making it look like it wasn't a big break when actually we all know it was. Because you can see the work of actually constructing the agencies to fit, like in the case of Social Security and public power, to fit within the ambit of what they thought the power gave them. So I think the answer is probably that in the case of those agencies, which are the ones that I studied, you know, it's not a radical break with what had happened before.
Yeah.
Yeah, I'd have to say it depends. I mean, I think that's a good answer. I mean, one thing, just the way I think you phrased the question, it's just at least worth acknowledging that all this power is legislative. All this power was created through legislation and
Right.
Delegations that Congress was involved in.
Right.
In the antitrust, you know, so I'm looking at two particular areas of public policy, so the industrial policy and antitrust policy, competition policy and agriculture. I sort of, you know, I think we have an emergency moment. The economy is grounded to a halt in 1933, and a 2-year limited statute is passed to address it. It's open-ended. It continues in some ways a movement toward antitrust provisionism that sometimes had support in the FTC in the 20s and sometimes didn't. It is open to interpretation. It gets pushed in a very anti-competitive fashion and crashes to earth. But competition policy, you know, continues in Thurman Arnold's antitrust division. So I see kind of a lot of competition there. Agricultural policy is a new beginning. It's a new policy that lasts for a very long time and changes pretty dramatically. So that strikes me as a bigger change.
Bob?
Yeah.
I wonder if there's nothing from the floor, if I can add the little bit your timing made me skip.
Please.
Which is Myers versus the United States, I think one recognizes as the linchpin of contemporary arguments about the necessary strength of the presidency. And what I would have said, and will say now quite briefly, is that it is an opinion that first dramatically overreaches its circumstances, and second, both reiterates Marshall's proposition and fails to go forward with it. So all that was necessary to decide in the case was the constitutional constitutionality of the proposition that had underlain the Civil War's Tenure of Office Act, whether the Senate could participate in removals. And even as to this question, the decision of 1789 on which it ostensibly rested was pretty unclear, very narrowly decided, and decided in the context of officers like the Secretary of State by a Congress that was also creating officers, for example, in Treasury, who were considerably independent of presidential control. And then in a couple of pages of the opinion, Chief Justice Taft starts by recognizing that difference between those who must be the president's alter ego in matters of that department where the president is required by law to exercise authority. Those are the officers that fit the Marbury versus Madison passage. And others who are engaged in duties prescribed by statute under the general administrative control of the president. Those are the ones that fit within Harold Leventhal's observation. Now one learns first when he was a young government lawyer and later in Ethical Corp for the DC Circuit, that these guys can do what they do only because we have judicial review of what they are doing. And then Taft boldly asserts that Congress can make no distinction between those two kinds of officers. It's a bold assertion. It is unsupported by anything except his assertion.
Thank you. So I had a question for Aditya to do with, and perhaps you mentioned this, but I missed it. In those common law writ contexts during that mandamus period, where it was private party A suing private party B, and part of the question presented was whether an agency had acted in an appropriate manner. In those cases, was there anything like what we would now consider to be Chevron deference? And what was the proportion of those common law cases to the mandamus cases? Were they outnumbered 10 to 1, or was it an even split? Just curious to know what you had found.
Sure. So with respect to the first question, the standard of review was essentially de novo statutory review coupled with application of the canons of construction that I discussed, the contemporary and customary canons. With respect to the second question, between, I believe, 1838 and 1880, the Supreme Court doesn't issue a writ of mandamus once to an executive officer. So there's about a 40-year period during which no writs of mandamus issue. And during that time, there are a number of common law actions, a whole host of them. So while I don't have the numbers, that maybe gives you some perspective on just the relative balance between use of the writ of mandamus and use of common law actions to challenge statutory interpretation. About 1838 to 1880 dates, they might be plus minus 1 or 2 years. But essentially what they track is the shift from the Marshall Court to the Taney Court. That's about 1837, 1838. And then kind of a period of dominance by people of that mindset.
What I'd add is that during that period, while one doesn't have Chevron deference, one has what later came to be recognized as Skidmore deference continuously.
I enjoyed the panel. I got a question for Aditya and then a question for the panel. Aditya, you mentioned this Edwards case and you suggested it was contemporaneous exposition of the statute. Then you also talked about the practice, and I wonder, is it one or is it both? Because one can imagine a newspaper or a congressman making a claim about what a statute means, someone outside the executive branch making a claim about what a statute means, and then the practice being at variance with it. What wins? Is it the contemporaneous exposition or is it the practice? And then for the panel as a whole, I find the realist discussion that the panel had was very interesting. What interested me in particular was why, or in the realist perspective, what difference does it make what types of arguments the lawyers make, right? If judges are doing what they want to do, why do they have any preference for what kind of arguments people make? Because I would have thought it almost doesn't, maybe I'm mistaken, but it shouldn't even matter what the arguments are, right, that the lawyers make, because the judges already know what they want to do. And maybe they understand that having arguments phrased in a particular way will conduce to them writing a better opinion. But as far as the outcome is concerned, I don't know what difference that should make at all. So it struck me as odd that a realist would care about the arguments that he or she made if they thought that the judges were going to do what they wanted to do anyway. I'm interested in your comments.
So a quick response. The two canons, they had two separate Latin formulations. These were considered to be two different kind of interpretive approaches: contemporary construction, customary practice. I did look. I was interested in the same question that you've posed, and I wondered whether there was some sort of authoritative or even any views on which wins out when there's a conflict between the two, which arguably is something that we experienced recently in the recess appointments case. But I didn't find an answer. It's not to say there isn't an answer out there. It wasn't the primary focus of my research. And so in an early draft of the paper, I flagged kind of this as something to myself that maybe would warrant some follow-up. And I haven't gotten there yet. What is interesting, just if I could quickly add an additional comment, is that there was a fairly large body of literature that predated the the founding of the American Republic. There's a fairly large body of literature by very eminent scholars. Thomas Rutherford, John Locke addresses this issue, and they're talking about the proper ways of doing interpretation. So there is kind of a lot of intellectual energy that's being devoted to this, and it's quite possible that we will find when if somebody goes through those treatises with your question in mind, that there were people thinking about this question.
On the realist question, I would say that that's a misstatement of the realist insight. The realist insight isn't that judges are going to do whatever they want. It's that it's that law isn't a mechanical process, and judges have biases and predispositions and politics, and they exist in the political world. And they also have professional training and professional biases. They are part of a dense network of other judges and lawyers. They come from a particular institutional context, and so you want to target your argument to take account or be cognizant of those biases, and rather than pretending that they don't exist and that law is like a slot machine and you just stick in the quarter and out comes the same result every time. So it's not a mechanical process, rather it's one that involves human beings who are part of social networks and part of civil society. I think that's the realist insight.
I do think that they viewed most of the time the justices' outcomes in a case or decisions in a case, or how they're going to come out, as inchoate before the briefing and the argument. And so very careful attention to how the individual judges think would help their results crystallize in a pattern that's consistent with their advocacy. I think Wyszynski's papers are just incredibly revealing, because he writes bi-weekly to both his mother and to Augustus in learned hand. So you can see the internal gossip of the New Deal in the letters to his mother, and you can see the more lawyerly critique to the hands. He really thinks that in the 35 term, the justices are the four Mastiffs and Roberts are just making it up. Cardozo says at some point, we are no longer a court. And at that point, they despair. They really despair, and they think we now no longer can shape something. So at that point, when they really think the justices, their minds aren't open, then they don't know what to do.
I can't speak to the realist question, and I haven't read the 19th century stuff nearly as thoroughly or carefully as Aditya has. But all of those opinions that I have read, and as I said, they're a continuous stream running from Edwards forward, reflect an understanding on my reading that when one is dealing with an executed opinion, if you like, by another element of government, that is an additional basis, if you like. This is not merely custom. It's not merely the established reading. It's that this reading was given by someone who had the legal responsibility to give the reading, and that, at least in the case of consistency, from the beginning, the Skidmore factors, if you like, is a special reason, part of government, for giving it weight.
Seems to me a major theme of most of what we've been hearing this morning is the idea that, I mean, it's really a frontal assault on any distinction between law and policy. I mean, at least in the old separation of powers sense that the courts will decide legal questions and the executive or legislative are going to decide a policy, and that sounds right to me. But I wonder whether within the executive branch there is when they are behaving as law interpreters and building a body of law with liquidation along the way and precedents and a requirement of continuity and explanation, and when the executive is able simply to announce interpretations of law afresh. It's new every morning. Every administration is as free as the one before to adopt a new tack. And this particularly comes up in Aditya's comments about the Edwards case and the distinction between whether deference is being given to the executive branch because of contemporary usage, which is a kind of liquidation, or whether deference is given to the executive branch because of its superior democratic credentials, which is partly a Scalian theme in the Chevron area. And I'm wondering, are these two ideas of what the executive branch is doing separable, or are they two different? Can you tell when they're speaking in one mode and when they're speaking in another? Or are we in a world in which executive deference to the executive is justified on the assumption that they are behaving in a kind of law-like liquidation, precedential explanation mode, but in fact, when they don't, they get just as much authority as when they do?
The hidden question in the city of Arlington is, what's the agency's authority? The court, again, as I read those opinions, the court agrees 9-zip that that is strictly a judicial decision. And of course, that answers, from a certain perspective, the question of law. The question of law is, what's the agency's authority? We decide what the range of the agency's authority is. And once we're finished with that, we've answered the question of law, and we've answered the question of law in a way that implies that the next question really is a question that Congress committed to the executive, and our function under the APA section 706(2)A is to say whether the executive has acted in a reasonable manner within the authority that we have decided that it has. I don't find anything in the city of Arlington that's contrary to that, although it's pretty much hidden, because Scalia, who doesn't like Skidmore, won't mention it.
Oh, but when you say left to the executive, you mean left to the executive to decide each day as it wants,
With
or
reasons.
left to an executive sort of understood over time as establishing principles and precedents and liquidating meaning?
There's that very clear distinction between the Skidmore kind of weight and what the agency does within what I've called its Chevron space. You don't get Skidmore weight if you've been inconsistent. Packard versus NLRB is a perfectly good example of that. But once we've decided that this is a policy area that Congress has given to the agency, then the issue is not they can reach any conclusion they have, but the issue is have they explained the conclusion they reached in a manner that satisfies our review responsibilities under section 706(2)A, arbitrary, capricious, and so forth and so on. And the court has been perfectly clear that within the Chevron space, that's what agencies are free to do. At Ernst, which precedes the APA, the Supreme Court starts out by saying, well, what's Who gets to decide what an employee, who an employee is? Well, it can't be the common law because that would be 48 different states. That couldn't be. It isn't Congress, because when we look at the statutes, Congress has been all over the map. They haven't decided who an employee is with any consistency. So what's left is the NLRB. This is a matter of labor policy. And as is notorious, the NLRB has gone from Republican to Democratic administrations, changes its minds on issues within its authority all the time. And the courts have accepted that, but accepted that within a framework of you have to show that you are reasonable and you can't defeat expectations that may have been created by the prior reading.
I'm sorry, just if I may, a quick additional response. I think Michael's question hits on the head the important policy debate that underlies much of this case law, and the basic policy values that are in tension with one another are flexibility on behalf of the executive. That's a value that Chevron extols repeatedly in the course of its opinion, and predictability on behalf of parties who are perhaps being regulated. So I think what Michael's asking, and I mean, I think this is true, is that over time, the progression of the cases, which we can either characterize as, proto-Skidmores or characterize them as I have, as involving application of these canons of construction. The progression is from more predictability, that's the value we really care about, to more flexibility, that's the value we care about. And what is kind of interesting, I think, this was raised yesterday as a question, is that in some of the hour deference cases of the last few years, you see sort of a reversion, and the court is saying, hold on a second, we need to insert some more predictability into the system. Now, whether this kind of policy role, I've always thought it's interesting. Chevron, of course, disclaims any kind of policy-making function, but this is policy-making on a grand scale. How do we trade off the values of predictability and flexibility against one another? That's where Chevron kind of leads us.
I had a question for Michele. So if I understood your argument, it is both that the lawyers at the time of the New Deal made strategic choices to present the programs as continuous and not requiring a radical legal break, but also that it was understood at the time as producing less of a radical break than as we now understand it.
Yes, both are true.
So I'm curious, and then you mentioned at the end that the narrative that we now have it's a post hoc explanation. I'm curious if you could say a bit more about how that change happened, how quickly, and why you think it happened.
Sure. Okay. So yes, both are true, and they're not independent, which is what I was trying to say to Bob. That strategic choices were made both in agency construction and in how to based on a prospective sense of constraint about what would be successful. And once agencies were already constructed, so the AAA had already happened, so they had to sort of figure out how to defend it. The Social Security Administration hadn't happened yet, so they got to figure out how to make it. So both of those things are true. And the story of how we came to see it as a radical break is a super interesting story, and I have a little bit in my book about this, but basically that story emerged in the mid-1960s, right around the time that Columbia was going around to New Dealers and doing their oral histories, and also a bunch of memoirs came out. And so the basic reason that we understand at least the Social Security, the unemployment, what I was talking about, the formation of unemployment as a federal state program, the reason that it actually happened was a political compromise with the very powerful Southern Democrats who were the chairmen of these subcommittees for which agreement was needed. They were a big important part of the New Deal coalition, and they were horrible racists. And the reason that they didn't want a federal program with any standards of any kind in the South was that they had basically a Southern system of racial peonage labor that was going to be completely disrupted by any federal standards in unemployment. And that, of course, was a political reality that nobody thought was deeply problematic in the mainstream in 1935, but everybody thought was deeply problematic in the mainstream in 1965. And so basically they were saving themselves from the taint of having made these political compromises with people who by 1965 were seen as deeply problematic, and also saving a new generation of Democrats like Kennedy and Johnson from the sort of taint of having made these compromises, particularly Lyndon Johnson, who was himself a Southern Democrat and implicated in racial problems at the time. So, Schlesinger's book and Francis Perkins' book, all of these people started to write memoirs and kind of cast these memoirs out in, like, say, 1961, 62, and the story of, well, we had to give in to the racists wasn't as good of a story in 1962 as it was in 1936. So that's part of the reason. The other reason is that it's just a better story, The old court, is the sort of negative figure, the bad guy, and kind of casting everything that went wrong with the New Deal onto the old court and everything that went right with it onto the heroic actions of the lawyers who kind of strode into, you had some book titles, the high noon conflict and, and we really, kind of beat the bad guys back. And the old court was a convenient foil for being the bad guy onto which all the flaws of the New Deal could be. Anything that went wrong was them. And forget those racists, like whatever. And, we were the good guys. And so I think there was a lot of kind of, hagiography that emerged around that time.
We reached our statutory limit, so I think we're going to have to strand runners on second and third.